So we're still in the midst of a criminal trial. We're about to start phase 2 of this trial. The burden of proof changes. The defense now has the burden, and the actual burden is no longer a criminal burden, but a civil burden. Despite that, given the fact that we're still in the midst of a criminal proceeding, I wanted to make a record about Mr. Cayer not wanting to come today. Mr. Cayer, what's the situation?
There's no point for my presence.
All right, but you understand that you have the right to be present in person in court?
I've always understood my rights.
And are you giving up that right here today?
Yeah.
Are you refusing to come to court?
There's no point for me being over there. I don't want to be there.
Okay, so when transport came to get you today, did you tell them you would not come to court?
Yes, and I discussed this with my attorneys yesterday while I was in the courtroom.
Okay, and it's your decision that you do not want to be in the courtroom or participate in the proceeding. Is that correct?
Correct.
All right. Mr. Cotton or Mr. Eichhoff, anything you want to add to that?
Yes, the only issue would be, of course, being able to communicate with Mr. Cayer or work with him during this stage. We did have a phone call with him this morning that the court had set up for us, so we spoke in fairly good light, I think, about this. I really don't have any competency issues. That was my initial thought, was there's something's happened here, but I really don't think this is a competency problem from my perspective. I think it's appears to be a decision that Mr. Cayer is making against our advice, but it's one I guess he can make, and I think that he's expressed that yesterday and again today, so I don't know if there's anything else I want to say about that.
All right, thank you. Mr. Lassay, anything you want to add? You know, in a criminal trial, I can require the defendant to be here. I could tell security to do what they needed to do to subdue him and to transport him. I think at the stage of the proceedings we're in, that's not worth the risk. I don't think that risk is necessary for court security or for the public or for anyone else. And I wouldn't want to have to put Mr. Cayer in that position either if he is waiving his right to be present. Normally, in a criminal proceeding, as I indicated, that's not how we would proceed, but we've shifted to the second phase. And I think that based on Mr. Cayer's statements that he does not want to be here, his attorney indicating that they've talked to him about that, they advised him to be here. Mr. Cayer, are you still listening to this proceeding?
Yes, I am.
All right. And I'm going to find that Mr. Cayer is waiving his right to appear at and participate in phase 2 of the proceeding of this matter, 16 CF 902. I find that that waiver is being made by him freely, voluntarily, intelligently, and understandingly after having been advised of his rights by his attorneys and by the court, and that he's making a choice to not be present today. Mr. Lassay, was the victim planning to participate in this part of the proceeding?
She was, Your Honor. I think that Kim had given her phone number to...
Okay. We're going to get her on the phone. We'll get her on the call and see what record we still need to make with the victim's participation.
Thank you. I anticipate there won't be any objection to what the proceeding or what the decision was.
All right, we just had the victim join us by phone. I apologize, there was some glitch. We've already started the proceeding. Mr. Cayer has expressed a desire to not be present at the second phase of the proceeding. His attorneys indicated that they've talked to him. I was just making a finding that I am finding that Mr. Cayer waived his right to appear at and participate in this proceeding freely, voluntarily, intelligently, and understandingly. Is there a victim who wishes to be heard at this hearing?
No.
All right. Anything further, Mr. Lassay?
No, I don't know if Mr. Cotton has any concerns that he would like to share, but I don't have anything specific at this time.
Mr. Patton?
We can take it up later or now, but I think some sort of jury instruction will be appropriate to let the jurors know what's happened here.
All right. Do you want to explore your client appearing, or at least appearing by Zoom?
I think his wishes have been made abundantly clear, and I don't think that there's an advantage to that.
Mr. Cayer?
I don't want to be present. I do not like you people, and I'm going to give everything to the newsletter, so fuck y'all.
Okay, well,
I
he
don't
just,
want to be present.
in addition to his kind words, he just flipped us off as well. So you do not want to participate by Zoom either, is that correct, Mr. Cayer?
Don't want to participate at all now, Zoom, or anything further.
Okay, thank you. All right, I do want to make one other record of one other issue because I didn't recall this, I didn't remember to do it when the jury was excused to begin their deliberations. During closing arguments, there was an objection by Mr. Cotton that the argument being made by Mr. Lassay was burden shifting, and I just want to make a record about that. I don't find that that argument was suggesting that the burden of proof somehow shifts to the defense. What Mr. Lassay was arguing at the time is if that was the defense of the defendant, they would need to establish that and present evidence of that, and that is accurate and correct. I don't think he was in any way suggesting that it was to the required of the defense to prove this case beyond a reasonable doubt or anything like that, so I don't think his argument was shifting the actual burden of proof. He was just establishing and making clear to the jury that if the defendant had more he wanted to articulate about what his defense was, then he could have presented more information in that regard. Anything else that we need to address before we recall this case and start the trial?
No, just the mechanics of getting Dr. Robbins on board, and we'll be ready to go.
And we can address that off the record and then discuss what kind of a jury instruction you may or may not want to be read to the jury.
Sounds good.
All right, thank you. Then this matter is adjourned temporarily.